Chapter 8. Subrogation of strangers. 240. Strangers or volunteers not entitled to subrogation. The doctrine of subrogation is not applied for the mere stranger or volunteer who has paid the debt of another without any assignment or agreement for subrogation, being under no legal obligation to make the payment, and not being compelled to do so for the preservation of any rights or property of his own. One person cannot, by his unauthorized payment of the price of land which another has agreed to buy, substitute himself to the vendor's lien upon the land. The doctrine of subrogation, said Mr. Chancellor Johnson, is a pure unmixed equity, having its foundation in the principle of natural justice, and from its very nature could never have been intended for the relief of those who were in a condition in which they were at liberty to elect whether they would or would not be bound. And so far as I have been able to learn its history, it has never been so applied. If one with a perfect knowledge of the facts will part with his money, or bind himself by his contract in a sufficient consideration, any rule of law which would restore him his money or absolve him from his contract would subvert the rules of social order. It has been directed in its application exclusively to the relief of those that were already bound, who could not but choose to abide the penalty. Sureties, for example, who have before become bound, are among the special subjects of its care. Another example of the application of the same principle will be found in the case where two creditors have mortgages or other liens upon the same property of the same debtor. Thus, if the subsequent creditor pay the prior debt, he is entitled to be substituted to the rights of the prior creditor as a means, without injury to the prior creditor, of enabling him to secure payment of his own debt. But I have seen no case, and none has been referred to in the argument, in which a stranger, who was in a condition to make terms for himself and demand any security he might require, has been protected by the principle. 241. The voluntary payment of a debt by a stranger extinguishes. Subrogation by operation of law exists in favor, not of all who pay the debt of another, but only in favor of those who, being bound for it, have therefore discharged it. The demand of a creditor which is paid with the money of a third person, and without any agreement that the security shall be assigned or kept on foot for the benefit of such third person, is absolutely extinguished by the payment. It is well settled that no one can be allowed to obtrude himself upon another as his surety, and therefore if a man voluntarily pays the debt of another without any agreement to that effect with the debtor, he cannot take the place of the creditor or recover the money so paid of the debtor, because the law does not permit one man thus officiously and without solicitation to intermeddle with the affairs of another. One cannot, by voluntarily paying money or rendering service for another, not having been requested so to do, make that other his debtor or subrogate himself to the rights of the creditor. A drayman, having contracted to haul and deliver to a vessel certain cotton, hauled it to the vessel and deposited it on the levee, at a place pointed out to him by the officers of the vessel, and left it there at their request, they declining to receipt for it on the ground that it was too late in the day. The cotton having been stolen in the night, the drayman paid its value to its owners, and brought his action against the vessel to recover the amount of this payment. But it was held that he could not recover, for the cotton had been delivered to the vessel. The vessel was liable to the owners of the cotton, and the payment by the drayman, being one which he was not bound to make, did not subrogate him to the right of those owners. 242. Application of this principle to the case of one who binds himself for a pre-existing debt. The owner of an equity of redemption, which was subject to several mortgages, gave his notes with an endorser to the first mortgagee for the interest which was due on that debt. The endorser paid these notes at their maturity, but no assignment of the mortgage was made to him. On a subsequent sale of the property, he claimed to be subrogated to the rights of the first mortgagee to the amount which he had thus paid, and so to have a preference over the subsequent mortgagees in the surplus proceeds of the sale after the payment of the first mortgage. But it was held that, as he was not a party to the original transaction, and there was nothing in the mortgage which provided for making him a surety, so as to subrogate him to the rights of the mortgagee, he is merely a volunteer, and accordingly was not entitled to the priority which he claimed. He could entitle himself to the benefit of the security held by the creditor only by an agreement to that effect, or by taking an assignment of a corresponding interest in the mortgage when he paid the note. The same principle has been declared in South Carolina. 243. Application of this principle to the case of one who loans money to the debtor for the payment of his debt. The mere loaning of money to a debtor to be applied by him in or towards payment of a debt, which was a lien upon his estate, does not of itself subrogate the lender in whole or in part to this lien, even though it was understood between the parties to the transaction that it would have this effect, unless there was such an agreement as to operate a conventional subrogation. One who has advanced money to pay off liens upon a ship will not by reason of this bare fact be subrogated to the benefit of the liens, unless at any rate it is clearly shown both that the money was so used, and that it was advanced for that purpose on the credit of the vessel. The lender of money which is applied by the borrower in part payment of the purchase money of land is not thereby subrogated to the vendor's lien upon the land, especially if this would prejudice the vendor's security for the amount unpaid, unless the parties appear to have so intended, or unless a fraud would otherwise be operated. One who pays off a prior encumbrance upon property in which he has himself no interest to be protected will not by high payment be subrogated to the lien which he has discharged, as against those having intervening interests in the property, even though, after the encumbrance had been really discharged by his payment of the debt, but not formally released, he took an assignment thereof, without the consent of the owner of the property. Nor is the rule changed by the fact of his acquiring an interest immediately upon high payment. If a guardian pays off an encumbrance upon his own land with his ward's money, it has been held that the ward is not thereby subrogated to the lien thus discharged. But if, when he made his payment, he manifested an intention to keep the prior lien alive for his protection, as by taking a quitclaim deed or an assignment from the prior encumbrancer, his payment will be deemed to have been made, not in extinguishment, but as a purchase of the charge, and he may hold under it. And one who has lent money to an infant to be used in purchasing necessaries or in paying debts incurred for necessaries, the money having been actually used for that purpose, has been allowed to hold the infant liable therefor by subrogation to the rights of the person furnishing the necessaries, though it may be doubted whether this was necessary for his protection. 243a. Application of this principle to the purchase of coupons on secured bonds. Where matured coupons on secured bonds of a railroad or other corporation are taken up with money furnished without the knowledge of the bondholders by a third party, without any assent on the part of the bondholders that this transaction should be regarded as a purchase of the coupons, they will not afterwards in the hands of such third party be allowed to share in the security to the prejudice of the bondholders. If the coupons have been paid on presentation at the place of payment with the money of a third party, a private arrangement between him and the debtors that he should be regarded as the purchaser of the coupons will not be enforced against the bondholders. Such a voluntary act will be regarded as a payment, not as a purchase, unless so intended by all parties. So the mere fact that money loaned to a railroad company was actually applied towards the payment of interest upon its first mortgage bonds or of operating expenses will not entitle the lender to any preference over the first mortgage bonds by way of subrogation. 244. Creditor not substituted to remedy of his debtor against a wrongdoer. One who has been injured by the act of a wrongdoer has no right, in consequence thereof, to be subrogated to the benefit of an indemnity which the wrongdoer may have taken against the consequences of his wrongful act. Nor though his debtor may by reason of the wrong have become unable to pay him, or may have been put to expense about the person to whom the wrong has been done, will he therefore be substituted to the remedy of such person against the wrongdoer. A plaintiff cannot recover against a defendant for injury done by the latter to a third person, though this injury causes also a loss to the plaintiff, by reason of his contract relations with or for such third person. A judgment creditor can maintain no action against one who has converted to his own use the goods of the debtor, though the latter had no other property, and the creditor is thus prevented from obtaining the satisfaction of his demand, unless this was done by fraudulent arrangement between the debtor and the wrongdoer, or unless the creditor has before the conversion acquired a legal interest in the property by means of an attachment or levy thereon, and then he sues in his own right, and not by substitution to the remedy of his debtor. The same principle applies to an action by a carrier against his servant for damages done by the latter to goods in his possession, for which the carrier has satisfied the owner of the goods. The action is maintained in the carrier's own right. 245. When the person making payment of the debt of another regarded as a stranger or volunteer. It is sometimes difficult to ascertain when one who has paid a debt will be considered to have been a mere stranger or volunteer. A payment made in pursuance of a moral obligation or by one who is liable to be compelled to make it will not be regarded as made by a stranger and will not extinguish the indebtedness of the party on whom rests the ultimate liability. So, where a guardian has been compelled to pay to his ward a sum of money due from a former guardian, on account of his having neglected to compel the payment thereof by the former guardian, he is by his payment subrogated to the right of the ward, and may recover the amount from the former guardian or the sureties upon the latter's bond. Neither directors nor stockholders are strangers to the corporation. They may be subrogated against both the corporation and other stockholders for payments of its debts, made by them in a fair effort to protect their own interest in the corporate property. If the corporate officers take no steps to redeem within the time allowed by law corporate property which has been sold on execution, a stockholder will, upon paying the judgment and redeeming the property, be subrogated to all the rights of the original purchaser at the sheriff's sale. If trust money is used by a trustee to pay off liens upon his own property, the cestuique trustant cannot be called volunteers and may be subrogated to the liens thus discharged. An agent who pays money out of his own pocket to protect the estate of his principal that is in high charge is not a mere volunteer, and is entitled to all the equities that the same payment would have given to his principal. The wife and children of one deceased who pay valid demands against his estate out of their individual means have been held not to be mere volunteers and may be subrogated. Said Thompson 0. J. The principles of subrogation do not apply in favor of volunteers. They can obtain the right of substitution only by contract. The cases which I have referred to illustrate who are not to be regarded as volunteers and strangers. One was the case of an endorser who was substituted to the judgment creditor whose judgment the proceeds of his note had paid. His endorsement was voluntary. Another paid for his own protection in execution on a prior judgment. He was not legally compelled to pay. A. Third and fourth advanced money, one in favor of an estate and one to his ward. They were all subrogated and not regarded as strangers. I regard the doctrine as applicable in all cases where a payment has been made under a legitimate and fair effort to protect the ascertained interests of the party paying, and where intervening rights are not thereby jeopardized or defeated. Such payments, whatever their effect might be at law in extinguishing the indebtedness to which they apply, will not be so regarded in equity, if contrary to equity to regard them so. But the payment must be made by one who really has an interest in discharging demand which he pays. Otherwise there will be no subrogation, as if he makes his payment under the mistaken belief that he is bound as surety. 246. Instances of the subrogation of a person on his paying the debt of another. A groom who has paid a farrier's bill for shoeing a horse under his charge will not be regarded as a volunteer, but will, after he has fully satisfied the farrier, be subrogated his reimbursement to the farrier's lien upon the horse. The clerk of a steamboat who has advanced the money for the payment of the wages of the crew on an order drawn by the captain upon the owners of the boat will be substituted to the rights of the crew as their equitable assignee. But not so if the money had been advanced by one not connected in any manner with the boat, or under circumstances showing that no such subrogation was contemplated. The payment of a planter's drafts in favor of his labor will not subrogate the party paying the drafts to the privilege of the workman. A county, having paid to the state the amount of estate tax for which its treasurer was in default, may be subrogated to the remedy of the state against the sureties upon the treasurer official bond. For, while the ultimate liability was upon the treasurer, the payment was for the relief of the county, and so could not be deemed to have been voluntarily made. So, where the general agent of an insurance company had appointed a local agent and taken from him a bond running to the company, conditioned that the local agent should pay over to the company all monies received by him, and the general agent had paid to the company certain premiums received by the local agent, but not accounted for by him. It was held, in a suit upon this bond brought in the name of the company for the benefit of the general agent, that since the latter had the appointment of the local agents and was bound, not only by contract with the company, but in order to keep his own position, to pay over all monies received by his subordinates, his settlement with the company for the local agent's defalcation did not discharge the bond, but he should be subrogated to the rights of the company against the sureties upon the bond. A new corporation, having paid the debts of an old corporation whose place it was organized to take, may be subrogated to the rights of the old corporation, though its only title was under an invalid receiver's deed. Where one, believing that he was a surety upon an administrator's bond, settled with the next of kin, who entertained the same belief, it was held, the discovery having been made that he was not such surety, and the administrator having become insolvent, that, having made the settlement and paid his money under a mistake of fact, he was not to be deemed an intermeddler, but must be regarded in equity as a purchaser for value of the claims of the next of kin against the administrator and the real sureties, and that he had an equity to be subrogated to the rights of the next of kin under the administration bond. And the general proposition has been laid down that one whose money has discharged claims against a trust estate which it was bound to pay, though he cannot maintain an action at law against the trust estate or the cestui que trust, will be subrogated in equity to the rights of the holders of such claims. But this must be limited to the case of one who has an interest in making the payment on which he rests his claim. 247. Subrogation of one paying a debt at the instance of the debtor. One who pays a debt at the instance of the debtor, under such circumstances that it appears to have been contemplated by the parties that he should become entitled to the benefit of the security for the debt held by the creditor from the debtor, may, as against the debtor and the debtor's estate, be subrogated to the benefit of such security and of the debt which he has discharged. And a party who has paid a debt at the request of the debtor, under circumstances which would operate a fraud upon him, if the debtor were afterwards allowed to insist that the security for the debt was discharged by his payment, may also be subrogated to the security as against that debtor. But this subrogation will not be allowed against one interested in the property held as security, who was a stranger to the transaction by which the payment was made, and who was under no obligation for the payment of the debt, unless it appears that the payment was made, not as an extinguishment of the debt, but in reliance upon, and as a purchase of, the security. This is a species of conventional subrogation, being a subrogation by an implied convention or agreement. Accordingly, it will not be allowed if it appears not to have been intended by the parties, though this intention, if not expressed, may ordinarily be determined from the circumstances attending the transaction. Nor can one be subrogated to an equitable lien merely because he has advanced to the real creditor the money with which the loan was made. 248. Conventional subrogation. It has been said that whenever a payment is made by a stranger to a creditor in the expectation of being substituted to the place of the creditor, he is entitled to such substitution. But the doctrine generally adopted, and that of these very cases when limited to the point actually decided, is that a conventional subrogation can result only from a direct agreement, express or implied, made with either the creditor or the debtor, and that it is not sufficient that a person paying the debt of another should have merely the understanding on his part that he is to be subrogated to the rights of the creditor, though, if the agreement has been made, a formal assignment will not be necessary. And the agreement may be shown by subsequent acts, which indicate a prior agreement. Thus, where a stranger pays the amount of an execution which has been put into the hands of a sheriff, a subsequent assignment of the judgment by the plaintiff therein to the person making the payment will be regarded as showing that the payment was made in purchase, and not in discharge of the judgment. And no claim by subrogation, whether conventional or by operation of law, to the securities held or the remedies enjoyed by a creditor for the collection of his demand, can be enforced, until the whole demand of the creditor has been satisfied. Until then there can be no interference with the creditor's rights or securities which might, even by possibility, prejudice or in any way embarrass him in the collection of the residue of his demand. Subject to these limitations, any agreement, whether made by the debtor or the creditor, for the substitution of the person advancing money for the payment of a debt to the securities, remedies, or priorities of the creditor, will, to the extent of the agreement, be enforced in equity, even against parties having intervening interests in the property held as security. 249. Conventional subrogation upon payment of a debt and a remedy for the payment itself cannot coexist. One who claims under an assignment of a debt and of the securities which were held for its payment, or under a conventional subrogation to the rights of the creditor, which is equivalent to such an assignment, cannot also claim the benefit of the payment which he has made for such assignment or conventional subrogation as a distinct ground of relief against the debtor. If he elects one remedy, he cannot also enjoy the other. He cannot, at the same time that he takes the benefit of the securities, claim also the advantages of having extinguished them by his payment. This principle was confirmed in a case in which it appeared that property was conveyed to trustees to raise £75, with which to pay off prior mortgages, which, with arrears of interest, amounted to that sum. The trustees did not raise the money, but allowed a third party to pay off the mortgages and to take transfers of them, and then made a deed purporting to assign to him the charge of £75 and to mortgage the property to him for that sum. But it was held that he could not charge interest on that sum, but that his right to stand as mortgagee was limited to the principal and interest due upon the mortgages that had been thus transferred to him. On the same principle, it has been held that a creditor who has obtained possession of property of an insolvent debtor held in pledge by another creditor, by paying off the debt due to the latter, cannot afterwards maintain an action to recover the amount thus paid by him without offering to give up the pledged property. 260. Conventional subrogation in Louisiana. In Louisiana, conventional subrogation to the rights and securities of a creditor in favor of a third person paying the debt can take place only by an express and formal agreement to that effect entered into by the creditor at the time of the payment. Accordingly, in that state, one who advances money to a debtor for the purpose of paying an indebtedness secured by a mortgage, under an agreement with the debtor that he shall, for his security, be subrogated to the benefit of the mortgage, will nevertheless have no such right of subrogation, unless the creditor was also a party to the agreement in the prescribed form. Nor will facts showing the intention of the parties that the person making the payment should be subrogated to the benefit of the securities held by the creditor be sufficient to effect this substitution, unless this intention appears to have been actually executed by a conventional subrogation. But since a conventional subrogation invests the person in whose favor it is made with all the rights and privileges of the creditor as fully as an assignment would do, one who has paid a judgment to the plaintiff therein and has been expressly subrogated to his rights may take out an execution thereon to his own use. For such an express subrogation is a sufficient authority to use the creditor's name for the recovery of the debt from the judgment debtor.